everyone. Good afternoon. My name is Theo Liebman. I'm the director of the Freedman Institute for the Study of Legal Ethics here. Many of you here know I teach ethics here, and I am really happy to welcome all of you here on behalf of the Institute, on behalf of the Maurice A. Dean School of Law here at Hofstra University. It is wonderful to be here in person, to see so many of you. There's a bunch of people on the Zoom as well. I think it's going to be a terrific panel. I do want to thank, before I introduce the panel, Debbie Grattan, who's the coordinator for the Institute, who's taking a job. Not here because I'm sure she's doing other stuff that keeps the law school running, is Judy Black, who's our director of thanks, Mark, director of management and facilities, and she really is what enables these things to get off the ground. So this is the Institute's first panel of the year, and it is really a great way to start for a couple of reasons. First of all, this issue, ethics accountability in the Supreme Court, is probably as much in the public eye as it's been maybe since Bush versus Gore, before a lot of the students were able to understand case law. Other than confirmation hearings, I think we read a lot in the general media about the Supreme Court when there's confirmation hearings. But recently, a lot of things have been really out there in discussion, not just among academics and lawyers. And I think there's a couple of reasons that is. One is what's been going on at the Supreme Court. And just to name a couple, about a year ago, a little over a year ago, when the January 6th House panel was trying to subpoena documents, one of the items they were trying to subpoena were text messages from Ginni Thomas to the White House on the day of the attack on the Capitol. And Ginni Thomas is the wife of Justice Clarence Thomas. Justice Thomas did not recuse himself. And that brought attention more than just ethics people and Supreme Court people and accountability people. That was pretty wide, pretty broad news there. And more recently, there was the Dobbs decision where footnote 48, by listing over a page's worth of cases, essentially made the argument that stare decisis isn't really a thing. The Supreme Court doesn't really need to be held accountable to precedential cases. So that also garnered a lot of public attention. So this is a very timely topic for us to be talking about today. The second reason this is a great way to start to have our first panel is we have these amazing speakers today. And I'm only going to briefly introduce them. You can Google them and find out a ton more, but it's because I know you would rather hear them talk than hear me talk about why they're so awesome. But I do have to first introduce them because it is worth a little bit of introduction. First to Alicia Bannon, who is the director of the Judiciary Program at the NYU Brennan Institute, and has written extensively and commented extensively in the public media about the need for ethics guidelines for the Supreme Court, what that would mean, how to do that responsibly. So thank you, Alicia, for joining us. And we also will be hearing from Eric Siegel, who is the Ash Family Chair Professor at Georgia State University. He has written also extensively, more broadly, on accountability for the Supreme Court. His most recent book is called Originalism as Faith, but the book he wrote that I think speaks most to the topic today, and I'm going to read it because I don't want to mess it up, is Supreme Myths: Why the Supreme Court is Not a Court and Its Justices Are Not Judges. So provocative, to say the least. You have a lot of friends on the Supreme Court? Yeah. All right. So. Finally, I really want to thank Mark Niles for so graciously agreeing to moderate this panel, and also to Professor James Sample, who really was instrumental in assuring. So instrumental in bringing these great speakers here. So I'm going to turn it over to Mark for what I am sure will be a great panel.
Okay, great. I didn't plan to stand to start. So I'm just going to, again, thank you, Teo, and thank you, James, for involving me in this. I'm very interested in the topic, more of an interested observer and questioner than anything else. But we're going to start with comments from both of the folks of our guests, and then we'll do various things. I think I'm going to give them an opportunity maybe to respond to each other for a minute if they'd like to. And then maybe I'll start off with some sort of question, give folks a chance to come up with ideas. We'd really very much like to hear from all of you in the time that we're going to have available. So let me stop talking. Have you guys decided who's going first? Okay. Eric Siegel, who I've actually known many, many years. One of the first people I met in my process of becoming a law professor, has been wonderful, very supportive. So great to see you again, Eric, and thanks for coming to this event.
Well, first of all, what a great turnout. Thanks for being here. I think we're both flattered to have garnered this size in the audience. I want to thank Theo and Mark and Alicia and James for arranging this. James and I are Twitter friends, have been friends for a long time. And I was just saying, in my 12 years on Twitter, I think this is my 10th invitation that came about in some way indirectly from Twitter. So take that for what it's worth. There is so much we can say about the Supreme Court and ethics. And if we wanted to speak directly about the kinds of issues that people are talking about, we could talk about the fact that the 9 justices on the United States Supreme Court are the only judges in America, local, state, federal, traffic court judges up to state Supreme Courts, that has no binding ethics code. That's insane. The highest court in the land should have a binding ethics code. There's no recusal rules. They recuse when they want, how they want, no explanations. I believe in the history of the Supreme Court, there have been somewhere between 3 and 4 memos written by justices explaining recusal decisions. That's insane. We have no rules about their papers, which we pay for, and which sometimes we don't see for generations after they retire or die. The writ of certiorari process is completely devoid of transparency, and we can talk about that in the Q&A because that's an issue that's not talked about very often. And of course, finally, there should of course be cameras in the Supreme Court so we can see what our highest judges are doing. But I'm not going to talk about any of those things, at least at the beginning, because I want to make a broader point about the Supreme Court and ethics. And it's a very big one, and it's one I've been trying to make for 30 years. I started teaching the same year Justice Thomas became a justice. I have tenure. That's probably a bad idea, but I have no power. The idea of and no influence, no one really cares what I say. For a Supreme Court justice to be serving his 32nd year or something is insane, and maybe we'll get into life tenure in a few minutes. But here's what I want to talk about. We have the Supreme Court of the United States is the least transparent branch of government. And when I say that, people say, wait a minute, Siegel, but they explain their decisions in writing. No, they don't. And this is the key point I want to make. They do give us reasons why they decide cases the way they do, and those reasons are in writing, but in no sane world are those the real reasons that motivated the justices. Because if the justices gave us the real reasons for their decisions, Justice Alito would have said, I don't like abortion, and therefore you can't have it. Or the liberals would say, we think affirmative action is a good thing. We don't care what the Constitution says. It's what we want to do. Those would be the real reasons. Those aren't the reasons we get. And this is the point I want to make about this. My wife teaches at the business school at Emory. She teaches problem solving. Before you can solve a problem, you have to identify the problem clearly. Otherwise, you're solving the wrong problem. There's been so much talk from the left in the last couple of years about doing something about the court. I agree with many of their proposals, but they're for the wrong reasons. The left wants to change the court structure because they don't like the judges on the court right now. Well, neither do I, to be clear. But that's not the reason we should change the Supreme Court. We should change the Supreme Court because it's not a court of law. And we can't figure out what to do with this institution that is unique in world history. Life tenured government officials with largely unreviewable power in a democracy. I'm going to say that again. Life tenured, people we don't hire, don't fire, can't elect, unless they can't fire unless they commit a high crime or misdemeanor, with virtually unreviewable power for life. It is a job that is inherently corrupted. It is, I don't mean in terms of bribes. I mean, all the justices eventually see the law as they see their own values. So in about 10 minutes, I'm going to show you that Text, tradition, history, and precedent are irrelevant how the Supreme Court decides hard cases. And if Justice Roberts tomorrow came out with a press release saying, my colleagues and I have talked, all 9 of us agree, from now on, we're going to make all things considered decisions. We're going to do what's best for America as we see best. We'll look at text, history, tradition, and precedent. We'll glance at it. We'll see what other smart people have said, but we're going our own way, and we'll do what we think is best. Well, that's not a court of law if he announced that, and we'd all agree on that. If he said that, every person in this room would say, no, a judge is supposed to take prior law minimally seriously. We can debate what the word minimum means in that sentence, but that requirement is a requirement of all judges in the history of free country. I am telling you that what our Supreme Court does is it makes all things considered decisions in the cases they care about. So here we go. Hold on to your seats. Text. It's irrelevant. It's irrelevant to everything. And it drives me nuts when they keep talking about text. Here are the reasons it's irrelevant. We all agree on freedom of speech, I hope. We all agree on freedom of religion, I hope. We all agree on equal protection, due process, that we shouldn't have unreasonable search and seizures, and we shouldn't have cruel and unusual punishments, and so on. We disagree about the application of those imprecise words to new facts and difficult questions. And the text can't help us solve it, and doesn't, and never has. It drives me nuts, this new textualist mood that we're in. It's irrelevant to constitutional litigation. It's not irrelevant to constitutional law. Wyoming gets the same amount of senators as California, which is insane, because it's written clearly in the Constitution. We can follow that. We don't litigate that. We don't litigate January 20th being the inauguration day, even though that's also really stupid. We don't litigate those things. What we litigate are the open-ended, imprecise aspirations that don't do anything in hard cases and can't, and stop thinking that it does. And David Strauss has written a lot, he's a professor at Chicago, about how text really doesn't matter. At the end of his long Harvard opinion, he said, well, we shouldn't admit it. And I wrote a response in the Harvard Law Review to that saying, you're right, you're right, you're right. And of course we should admit it, because that's called ethics, that's called transparency in government. In the Dobbs opinion from last term, Justice Alito made a huge deal out of the fact that the right to terminate a pregnancy is not in the Constitution, and text. Yeah, except here we go. Here are the rights that we all have that are not in the Constitution, according to the Supreme Court of the United States. We have the right to raise our children as we see fit, not in the Constitution. We have the right to refuse medical treatment for a competent adult, not in the Constitution. We have the right to travel, not in the Constitution. We have the right to send our kids to private school, not in the Constitution. We have the right to contraception so far, not in the Constitution. There's a fundamental right to marriage, not in the Constitution. There are limits the Supreme Court has put on Congress, the anti-commandeering doctrine. There is no anti-commandeering clause. There is no dormant commerce clause. Huge case last week about meat in California involving the dormant commerce clause. And everybody acted as if there is a dormant commerce clause. There is no dormant commerce clause. It's not in the Constitution. There is no federal equal protection clause, and I can go on and on. Text doesn't matter. So one of the tools that justices and judges use to act like judges and justices is text. It doesn't apply to constitutional law. And by the way, the only provision in the Constitution that is crystal clear, that has gotten a lot of litigation, is the 11th Amendment, which in relevant part says no state can be sued by a citizen of another state. That's not unclear. The word another is not imprecise. It's not like equal, right? We know what the word another means. The court interpreted it to mean the same. And a constitutional provision that was meant to stop a citizen of South Carolina from suing Georgia now stops a citizen of Georgia from suing Georgia. It's made up. It's nonsense. It's atextual. It's non-textual. Actually, it's anti-textual. Text doesn't matter. Throw it out the window. All right. History. We can say a lot about history. I don't have the time to go through it. My book, Originalism is Faith, makes out the case that the Supreme Court has never cared about history. It's simply an after-the-fact rationalization for decisions made on other grounds. But here's the thing. The history we're talking about is either 1791 or 1868. First of all, women couldn't vote at either time. So we're talking about relying on history where half the population was unable to vote. Of course, we had slavery prior to Reconstruction amendments. History is either irrelevant, which it is most of the time. President Obama assassinated an American citizen having lunch in Yemen with no due process because that person having lunch in Yemen was a terrorist. But no court had found him to be a terrorist. Should the president be allowed to assassinate an American citizen having lunch in Yemen? I don't know the answer to that question, because he could have blown up New York with a cell phone, maybe. Here's what I do know. James Madison had no idea. And no one in 1789 can help us with that question. And that's true for most of constitutional law. It's either irrelevant or contested. Now, law professors debate the history of the Second Amendment. Historians do not. Historians do not. 99% of historians know that the Second Amendment was never about an individual right to own guns. But law professors debate it, so it's contestable. It doesn't really help. And then finally, even the conservatives do this, of course, times change. So the 14th Amendment was not meant to protect women. We know this. The Supreme Court in the 1880s held that women had no right to be lawyers in Chicago, in Illinois. As late as 1940s, Michigan stopped women from being bartenders. Supreme Court said fine. But today's originalist law professors, who aren't crazy, understand that women need to be equal. So we don't care about the history behind the 14th Amendment. We care about today. Because 99% of Federal Society law professors think women are protected by the Equal Protection Clause, even though there's no original argument that they are. We don't care about history, it doesn't happen. And then final, and tradition, forget tradition, I'm going to prove this to you in one story. Next June, or this June, the Supreme Court's going to make us all be colorblind in our admissions policies in thousands of colleges and law schools across the country. They're going to do that. They're going to say colorblindness is a constitutional requirement. The phrase colorblindness does not appear, colorblind does not appear in the Constitution. Not one time you won't find it. The word race doesn't even appear in the part of the 14th Amendment the court is going to use to strike down racial criteria in admissions. As far as the original meaning of the 14th Amendment goes, all the historians have shown they knew that we needed programs that were race-based to help the newly freed slaves. But the most frustrating thing of all is tradition, which was such a big deal in the gun case last term and Justice Scalia's pet peeve. Tradition. There's never been a second in American history when we were colorblind. Not a second. We went from slavery to segregation to black codes, then to segregation, and then eventually Richard Nixon in the late 60s pressured Michigan, Yale, and Harvard to take more people. We've never been colorblind. It's not a thing. It's not a thing in the text, the history, the tradition, and the Supreme Court was asked in 1978. Impose a rule of colorblindness? No. They were asked in 2003, impose a rule of colorblindness? No. They were asked in 2016, impose a rule of colorblindness? No. 3 big cases. Next June, the court's going to impose a rule of colorblindness in complete contradiction to text, history, tradition, and precedent. The most important footnote of the second most important footnote in Supreme Court history, in my opinion, is footnote 48 in Dobbs, the abortion case. It is 2.5 pages single space. Imagine being the law clerk on that one. 2.5 pages single space. According to Justice Sam Alito, it was, quote, a partial list of important cases the Supreme Court has overturned. A partial list. 2.5 pages single space. It turns out that in every litigated area of constitutional law, without exception, First Amendment, Second Amendment, Fourth Amendment, Fifth Amendment, Sixth Amendment, Eighth Amendment, 10th Amendment, 11th Amendment, 14th Amendment. The Supreme Court has turned itself around, gone 180, changed its mind for all of American history. This term, and last term, and this coming up term, where the court's going to disregard 50 years of affirmative action precedent, are not outliers in kind. They're only outliers in degree. The court has never cared about precedent. They don't care about text, they don't care about history, they don't care about tradition, and they definitely don't care about precedent. If you don't believe me, I have a list of like 30 cases, but I'm running out of time, so I won't go through them. But I do want to tell one last story. Do I have 5 more minutes? Please. So this institution is broken. It's not that the people are broken, it's the institution is broken. Don't give government officials life tenure and unreviewable power. Terrible idea. No other country does it. This is not a new moment in time. This is an old moment in time we're experiencing right now. So I want to take you back to 1870. During the Civil War, for the first time, Congress printed paper money. They'd never done it before because the Constitution only talks about coin. But the North needed to fight the Civil War. So the Secretary of the Treasury and the President get together and they decide, you know what, we're going to print paper money. It's going to help us fight. And they did. The war ends. There's hyperinflation. And creditors want to be paid back the debts that they are owed with gold and silver, not these new greenbacks, these new hyperinflated paper money dollars. And in 1870, a creditor who was paid back with dollars sued and said, no, I want gold and silver, and challenged Congress's authority to make paper money legal tender for prior debts. This is an 1870 case. Writing in 1935, an eminent law professor said that was the most watched case in Supreme Court history from 1789 to 1935. The most important case ever. The most talked about, the most written about, the most debated in the newspapers, the most scholarly attention. And in this 1870 case, decided along partisan lines, the Supreme Court holds Congress does not have the power to make paper money legal tender. Huge decision, just huge. It also implicitly reversed McCulloch versus Maryland. Those of you taking con law know McCulloch versus Maryland is one of the most important cases. This opinion effectively repealed it, overturned it. Didn't expressly do it, but it did. Turns out the day of the decision, Grant gets 2 picks. And the entire world knows that he's a litmus test. Yes, a litmus test. He's only going to appoint judges who will reverse that case. And everybody knows, everybody. He gets his 2 picks. And 1 year, and by the way, that opinion is like 70 pages long and 50 pages of dissent. 1 year later, with nothing changed, not the text, not the history, not the tradition, nothing has changed, except 2 new Republicans on the Supreme Court. Back then, Republicans cared about the poor and the Democrats didn't, roughly speaking. And this new Republican Supreme Court reverses itself after 1 year on the most important issue in the history of the Supreme Court, and the world went crazy. And newspapers said Grant packed the court. And newspapers said, and I quote, Grant put his cronies on the court to do his bidding. And people were talking about what we can do to bring back the Supreme Court to a place where we can live with it. And so on, 1870, 1871. If you were alive in 1857 and you were a moral human being, you would have been really upset that the court said Congress couldn't end slavery in the territories. If you were alive in 1935 or 36, you would have heard Theodore Roosevelt, Franklin Delano Roosevelt say that we have to save, on national radio, we have to save the Constitution from the court, which is full of, quote, aged and infirm old men. And we can't get out of the Depression until we do something about it, and he did his famous court packing. This moment is not new. And the reason this moment is not new is because this institution was built to be unethical and unaccountable. And it's not complicated to see why, and I'll sit down repeating this one more time. Never, ever give a government official unreviewable power for life. It corrupts. Thank you very much.
Thank you all so much for joining us here today, and to the Freedman Institute for the opportunity to participate in this excellent conversation. I'm really excited to be here today. I'm going to make a somewhat different argument. I'm going to suggest that this moment is new, at least in our recent history, in some important ways. And what I'm going to focus my remarks on today is judicial legitimacy. And specifically, what does Dobbs and some of the other recent decisions that we've seen coming out of the Supreme Court, particularly this new supermajority, conservative supermajority on the Supreme Court, as well as some of the conduct that we've been seeing from justices on the court, what does that mean from the perspective of judicial legitimacy? And what does that in turn mean for the future of the Supreme Court? In a lot of ways, judicial legitimacy, I'm a court nerd, so I've been reading about judicial legitimacy for years, but usually I've been speaking to myself. But now it's sort of having a moment. It's been an unusually pointed topic over, particularly over this past year, and not only by critics of the court, but also by the justices themselves. We've had just in the past month, at least 3 different justices make public comments about, the legitimacy of the court, either responding to perceived criticisms or in turn criticizing the court. We've heard from Chief Justice Roberts, Justice Kagan, and Justice Alito. And it's been unusually pointed. Usually if you hear the justices talking about the court, it's a very clear script. We may disagree on the law, but, we are all friends, we're all colleagues, it's all about doing justice. That has not been the tenor among justices in some of their public remarks recently. Justice Holmes famously once, called the court 9 scorpions in a bottle, fighting with each other. And now we've kind of seen the scorpions crawl out of the bottle, and now they're on the lawn and they're fighting with each other in public. So we've seen, just recently, Chief Justice Roberts gave a speech. He was, responding to these perceived attacks on the legitimacy of the court. He says, but simply because people disagree with an opinion is not a basis for criticizing the legitimacy of the court. You don't want the political branches telling you what the law is. You don't want public opinion to be the guide of what the appropriate decision is. Justice Kagan responded, not by name, but very pointedly in response a few days later. She said, judges create legitimacy problems for themselves when they don't act like courts and when they instead stray into places that look like politics. She said, if the entire legal system is up for grabs whenever one justice leaves the court and another justice joins the court, that doesn't seem a lot like law. For his part, Justice Alito responded a few days later in the Wall Street Journal. He says, it goes without saying that everyone is free to express disagreement with our decisions and criticize our reasoning. But saying or implying the court is becoming an illegitimate institution or questioning our integrity crosses an important line. So I'd like to weigh in on this debate today and suggest that Justice Kagan has the better of the argument here. But first off, what do we mean when we're talking about judicial legitimacy? Because a key thing to understand is that it's different than public approval. So you may have seen headlines recently, court has record low approvals, there were some Gallup polls, the court had the lowest approval rating in at least the history of since Gallup has been doing those measures. And that's important, but approval has waxed and waned over the years. If you looked right after Bush v. Gore, approval went very down. It's not something that has been consistently high over time. That's very different than legitimacy. Legitimacy is the concept of respect for the court as an institution. And to put a finer point on it, a willingness on the part of litigants and the public as a whole to respect and abide by decisions that the court is making, even when you disagree with them. And that is so important for the court as an institution because, and this is sort of a cliche, but it's true, right? The court doesn't have an army. It doesn't have the power of the purse. Legitimacy is the whole ballgame. If people don't respect what the court is doing, if people don't say, I don't like what's happening here, but I understand that I'm still bound by the court, there's not much that the court can really do as an institution. And what we've seen, at least in modern history, is while that approval has waxed and waned, the court has retained a consistent, very high level of public legitimacy. People like the roads, people trust the system, and that has allowed the court to even, at times do things that are unpopular and still have the public more or less, come along. And it's a linchpin of the rule of law. Imagine a world where you had court rulings where people really didn't think they had to follow them, and you had widespread defiance of court decisions. After Obergefell came down, Roy Moore, who was then the Chief Justice of the Alabama Supreme Court, sought to defy the court's ruling. Said, we're not gonna give out marriage licenses to same-sex couples. He was almost immediately removed from office. As a matter of judicial misconduct. That was seen as outside the realm of what was appropriate. But you could imagine a very different world where you would simply have widespread defiance in particular states. If you don't agree with the court's decision, we'll just go along. And then, and that would be a real crisis of the rule of law. So is legitimacy now at risk? I would say yes. And I think it's important when we're unpacking what that means to understand that there's sort of two concepts of legitimacy that often get conflated when people are talking about the legitimacy of the court and, some of this back and forth that we've seen from the justices as well. There's both a descriptive element and a normative element to that question. So in other words, factually, does the court enjoy legitimacy? Do people perceive the court as an institution that has to be respected? And then normatively, should it? Is the court earning that public trust? And I would say on both fronts, there's reasons to be very concerned about the legitimacy of the court right now. Descriptively, I think there's reason to think the court's legitimacy is at risk in a way that it has not been in at least the recent past, modern history. So up until recently, for example, while the court has been overall very conservative, it had swing justices that led to very important rights protective victories, even at a time when the court overall was tacking in a more and more conservative direction. To give just one example, the same term that brought us the Shelby County decision, where the court gutted the protections of the Voting Rights Act, also brought us the Windsor case, where the court struck down the Defense of Marriage Act. And that dynamic of you win some, you lose some, is very important for an institution that depends on public trust. To go back to Chief Justice Roberts, the famous umpire example, we're calling balls and strikes. It's harder to think that you have a fair system, right, if one side is always losing the game. But I recognize there may be Mets fans in this room, so maybe we're all used to losing a lot of games. Let's do a Mets joke. I'm a Mets fan. I was raised as a Mets fan. But you putting that aside, oh no, it's leaving the room. I've lost my audience.
You've lost your legitimacy.
I've lost my had to do a Mets joke. But it's a lot harder for people to think of justices as umpires, right? If one side's always winning the game, that starts to feel like there's an unfairness in the system. And it's also new right now in the past 50 years that you have a court that so you have a court now that across a very wide array of high salience, politically important issues is swinging very strongly in a single direction and often in a way that's very unpopular. It's also new that you have a court where the ideological leanings of the justices line up perfectly with the political party of the president who nominated them, and where the Senate has had an unprecedented role in playing constitutional hardball to stack the court in one direction. And so, just recently, the New York Times had an editorial where they talked about the Supreme Court and said, I quote, "The court has been transformed into a judicial arm of the Republican Party." And that's pretty shocking language from the New York Times, like a pretty centrist, mainstream, rule of law institution to be characterizing the court in that way. And simply descriptively, you wouldn't have been able to do that until recently, because factually it just wasn't the case that the justices just factually had been so closely linked with the conservative legal movement and with the Republican Party that nominated them. So it is just different in kind in very important ways, even to our relatively recent history. But then also, and this is where the normative considerations come in, the Supreme Court has not been behaving in a way that suggests an institution that's really looking to shore up its legitimacy. And I've been thinking, we've been thinking about different ways of talking about the Supreme Court and, characterizing this new supermajority that we have. Sometimes I've talked about the radicalization of the Supreme Court as a reactionary court, but I think really what I've come down to is it's a maximalist court. We've seen maximalist behavior on the part of the Supreme Court in ways that, again, really go to these questions of judicial legitimacy. You've had consistently across a whole host of areas, in high-profile cases and lower-profile cases where the court is deciding cases more broadly than necessary, not showing a respect for precedent, not showing a respect for other kinds of prudential constraints on the court's behavior, and not respecting reason giving, explaining why it's ruling in the ways that it's doing so. And, to go back to Justice Kagan's point, in many of these decisions, it does seem clear, right? What has changed between a prior ruling and now? What's changed is personnel. So to give a couple of specific examples, we talked about Dobbs at the beginning, and I think it's hard to talk about this court without talking about Dobbs. Stare decisis looms large over that case. That's the most dramatic way, right, that the court departed from decisional norms. But it's also a case about overreach. If you have to remember, what was before the court in Dobbs? It was a 15-week abortion ban. And if you look at the original petitions to the court, if you look at the original arguments that Mississippi was making, they weren't seeking to overturn Roe. They were arguing that this ban was consistent with the frameworks that the court had already presented. And in fact, Justice Roberts, he concurred. He would not have overturned Roe. He would have allowed Roe to stand, or allowed that framework to stand, and with kind of the death by 1,000 cuts, narrowed it in various ways so that ban would have been upheld. Mississippi only raised the argument that Roe should be overturned after Justice Barrett joined the court, when you saw that personnel change and you saw a court kind of embrace that opportunity, and rather than a more gradual approach, rather than trying to work within the frameworks, they went and full on lack of respect for precedent overturned Roe and Casey. You know, another case I'll highlight is West Virginia v. EPA, another really important case that came out of the term. There we saw the court embrace the new principle of major questions doctrine. Here too, it was a ruling on an Obama-era regulation that the Biden administration had already said it wouldn't enforce. There was no reason to decide this case. I would argue this case was moot and they probably didn't have the power to decide it, but at the very least, there were strong prudential reasons for them to not weigh in here. But again, the court, it kind of felt like a smash and grab, right? You have this opportunity to push the law in a direction and the court was going to take it. And we've seen that in case after case. Rather than going for a kind of narrower ruling, deciding a case on the facts before you, deciding only what you have to issue a ruling in the case, the court has embraced this maximalist approach to decision-making that I would argue does real damage to its legitimacy, both descriptively and normatively. I want to make sure we leave plenty of time for questions, so I'll just briefly note also the rise of the shadow docket, where we've seen a whole host of rulings where the court has been making essentially substantive decisions using its emergency docket without the benefit of argument, often without any kind of written opinion at all. We were talking about reason giving being public. You're not getting any reasons at all in some of these instances. You know, SB 8, the Texas abortion ban, went into effect without a word from the court. You know, eventually they took it up and there was arguments, but initially they just let it go into effect. You know, and you've even seen, there's another case, Louisiana v. American Rivers. This was another case about environmental regulations coming out of the Trump administration. And, you know, there too, they reinserted an administrative rule without providing any explanation of why they met the legal standards at issue. You know, there's an irreparable harm standard there. They didn't give an explanation. And so, you know, time and again, we're seeing the court kind of take these maximalist approaches and kind of deviating from the principles, the constraints on judicial behavior that give the court its public legitimacy. We've also seen a disturbing pattern of ethical lapses. And, you know, we talked a bit earlier about the infamous Ginni Thomas text and Justice Thomas's failure to recuse himself, something that was, I note, while there is no code of conduct that binds Supreme Court justices, there is a law around recusal, but I think pretty clearly applied here. And, you know, Justice Thomas, I think, was pretty clearly obliged to step aside from that case and not only failed to do so, but when all of this information came out, failed to give any explanation as to why he didn't. You know, maybe there were facts that we're not aware of. Maybe he truly was unaware that these texts existed, but there was no public explanation either about his decision to not recuse himself, even at the time or when those texts became publicly known. We've also seen a broader pattern of partisan speeches, lavish gifts, recusal failures in other contexts, you know, and particularly with justices appearing with partisan actors, with litigants, with groups with strong ideological associations, again, in a way that contributes to the perception that the justices are very closely tied with politics. You know, to give just one example, last year, Amy Coney Barrett gave a speech where she argued, you know, the case she was going to make is that this court is not comprised of a bunch of partisan hacks. And she gave it at the Mitch McConnell Center at the University of Louisville, where the Senate leader, who breached Senate norms to confirm her, introduced her before her speech. It's those close ties that don't look good, that sort of suggest this association with political actors that can really undermine public perceptions of legitimacy. And is it happening? I would say there's evidence that it is. A recent Pew survey, for example, found that only 16% of adults say that the justices do a good or excellent job of keeping their own political views out of their decisions. And that's a crisis for an institution that relies on public trust, that they are above politics, that they are not just fully immersed in that rough and tumble. Now, some might say this is a good thing. You know, the veil is lifted. We're seeing it's been about politics all along. I push back against that characterization. The court is obviously a part of politics. It is a branch of government, of course. But I don't think that the court is, or at least should be, just another political body. Courts play a unique and critical role in our democracy. And they're rooted in a profoundly important principle that we have to have a space in our democracy, whereas in the words of Justice O'Connor, being right is more important than being popular or powerful, and where fairness trumps strength. And that place is supposed to be the courtroom. And we need courts that are there to defend our rights and ensure we have the background conditions for democracy to function and thrive. Now, the court, and so how do we get there? We need courts and judges that are constrained by interpretive norms, by procedural rules, by prudential principles that encourage gradualism, constraint, deference to political bodies. And these are exactly the places where this maximalist court has really lost its way. Those are the places where the court has most dramatically deviated from where we need a court to be. So where do we go from here? I want to talk more about term limits and codes of conduct for judges. I also think having these kinds of conversations is important. I think public scrutiny, public conversation about what's happening with the court and calling out these concerns about legitimacy is a really important part of the dialogue that you need to have between the court and the public. And the court does, I think, sometimes pay attention to those kinds of pressures. I think we need to think structurally about different ways of reforming the court and shifting some of the incentives so that the court doesn't have the same incentive structure to go maximalist, and so that we don't have a judicial nomination and confirmation process that, again, encourages the politicization of the court and of that process writ large. So I'm happy to talk more about that in the Q&A. And again, thank you again for the opportunity.
I'm going to take moderator privilege and say from now on we're going to sit down. Second, Professor Diggle, I want to give you a chance to respond. And also, if you would include in your response, you talked a lot about the problem, which was great. Just if you could quickly talk about some of the things you might see as solutions. And then I want to go to Professor Eric Freedman, who's going to provide some response and some perspective on all this, and then we'll get to questions. So, Professor Diggle, if you could maybe respond a bit and also say what would you like to see change?
Well, first of all, I agree with almost everything Alicia said, with one exception, which is I don't think this is a moment of time that's different from other moments in time. Sorry, can you hear me? How's that? What happened there? I think you've had this moment in time before. I also want to be fair and balanced. This is important to me.
Yes.
I want to talk about Elena Kagan for a second. A woman I admire tremendously, and as Dean of Harvard did an amazing thing. Harvard was dysfunctional law school faculty, and she fixed that. And if you can fix Harvard, you can fix almost anything. I want to talk about Elena Kagan and what corrupted her. So she was the Solicitor General of the United States. And in that capacity, she celebrated the passage of Obamacare the day it was passed with an email to Professor Lawrence Tribe, who at the time was the most famous constitutional law professor in America, and I think an informal advisor to the Obama administration. And she said, "We have the votes, yay." Then her deputy came to her and said, "There's going to be lawsuits tomorrow in Florida and other places challenging Obamacare." The Solicitor General's Office of the United States represents the United States government and the United States Supreme Court. It almost never gets involved in lower court litigation, but it does when it's really super duper important. And the question that Neil Cattell asked Elena Kagan was, do you want to be involved in the litigation of Obamacare in the lower courts? That's in the record. I'm paraphrasing, but that's in the record. Her answer was, I'll come to your meeting, but I'll come to a meeting, but that's all basically. And Elena Kagan then testified under oath years later that from that moment forward, she had nothing to do with the Obamacare litigation in the lower courts, that she turned it over completely to Neil Cattell, who in fact argued the case in the 11th Circuit and other places. When she became a Supreme Court justice, she recused herself in well over 200 cases, including a huge affirmative action case and a huge immigration case. She did not recuse herself in the Obamacare case, and that was absolutely 100% wrong under the law. There is a law that binds all judges except the Supreme Court, but the court is technically supposed to comply with it. That says, of course, you can't be a judge if you litigated the case below as a lawyer. Of course, you can't have a lawyer litigating a case and being a judge in that case on appeal. The only case in the entire time she was Solicitor General that she told Neo Cattell, don't tell me about it, don't talk to me about it, was the Obamacare case. She did not do that about affirmative action. She didn't do that about immigration or 250 or so other cases. Why that case? We know why that case. Because she knew that she was going to be possibly nominated for the Supreme Court, and she knew she wanted to rule on that case. That's wrong. It is wrong as a matter of ethics, it's wrong as a matter of accountability, and she never is, and despite a formal motion by a non-party for her to recuse, she never said one word about why she didn't recuse. Here's the point I want to make, and it's a big one. And I wrote a lot about this, a liberal's lament, because I wanted Obamacare to pass, and we all thought that if Kagan recused herself, it wouldn't. The Supreme Court would strike it down. Here's what went through her mind, I'm guessing. 30 million Americans get health insurance, or I follow technical legal rules. Not a close call. I don't blame her for that. Were I in the Supreme Court, when I wrote an op-ed about this for the LA Times, I got a letter from a non-lawyer saying, you say you're a liberal, you say you're for Obamacare, why do you want to threaten it through technical recusal rules? 30 million Americans will suffer. Fair enough. That's the problem with our Supreme Court. If they care enough, they will do anything, which is why, and then I'm going to answer Mark's question and stop, which is why Justice Ginsburg and Justice Marshall, two American heroes by any definition of that word, the most important civil rights litigator in history, for people of color, the most important civil rights litigator for women's rights in history. Two American heroes before they got to the Supreme Court. They both deserve all the honor we can give them. And they voted liberal progressive 99% of the time. They voted liberal progressive as often as Alito and Thomas vote conservative, which is 99% of the time. And then people say, what about Stevens, White, Blackmun, Souter, and O'Connor, and Kennedy, who flip back and forth? Fair question. The answer is, guess what? They were political moderates. So what did they do? They voted moderate, and they swung. Alicia's right that this is the first time we've had 5 or 6 conservative Republicans, 3 or 4 liberal Democrats, and it's broken up like that. But from 1857 until today, it is ideology that drives Supreme Court decisions, not text, tradition, history, and precedent. And that's always been true. And if you had life tenure and could do what you want without any discrimination, you would vote your preferences as well. And so would I. Finally, what I would do is what I said I would do when Justice Scalia died in 2016, and the court had 4 Republicans and 4 Democrats, and the most liberal Republican Kennedy was more conservative than the most conservative liberal Breyer. I said, and I'm a board member of the American Constitution Society, and they disowned me for 6 months. Their slogan was, we need 9. Remember that slogan, we need 9? My slogan was 8 is great. I wrote a piece in the New York Times and for law reviews saying that we should have an equal number of Republicans and Democrats on the Supreme Court. I came up with a statutory method to do it. The original number was 6, so if you're an originalist, an even number can't possibly bother you. The number is not in the Constitution, Congress makes it up. With an evenly divided Supreme Court, all the things that Alicia so beautifully spoke about, narrowness, only deciding what's necessary, compromise, all those things would come about. In fact, we had that court for a year, and Elaine Kagan said at the end of the year, we never worked better together than in the year we were 4-4. Now, she also said we need 9, but that's because she thought Hillary Clinton was going to win. She might not have said that if she had thought Trump was going to win. I had a way of getting independence on the court if there was a very popular independent who wanted to get on the court. But my proposal, and imagine Schumer and McConnell going on national television at 9 o'clock and live streaming at 9 o'clock and saying, you know what, we're done with the Supreme Court being this big a player in national politics. From now on, we agreed, like we agreed to filibuster, it's going to be an even number of Republicans and Democrats. If a Republican dies and the Democrat is in office, the Democrat president has to nominate a Republican. I have an entire method whether the Judiciary Committee can make sure it's a real Republican, not a fake Republican, or vice versa. European countries, some of them have constitutional courts that are even numbers. That would be my one proposal because it is totally and 100% bipartisan in the long run. Obviously today it would help Democrats, but in the long run, it's a bipartisan proposal.
Alicia, I'm going to give you a chance, if you want to say something in response to that, or we can go. Just up to you.
Well, maybe I can just note quickly a few reforms that I think
Please,
are
that'd be
worth
great.
thinking about, and then
I think that's a good start, and then we can get to questions.
Sure. Well, I mean, just briefly, I do just want to emphasize the fact, as Eric noted as well, the Supreme Court is the only court in the entire country that does not have a and that's something the court could fix tomorrow. The court could tomorrow announce that they are going to follow a code of conduct, make it public, allow for that public transparency and scrutiny and accountability. I think absent the Supreme Court taking those steps, I think it is appropriate and timely for Congress to step in and require the court to adopt a code of conduct. And I think there's ways that you could structure that would be respectful of judicial independence. I think another critical step would be the court being required to give reasons for recusal decisions so that you have that element of transparency and accountability. So we hear from Elena Kagan, we hear from Justice Thomas when, about their decisions not to step aside from cases when there may be a perception of a conflict of interest. In terms of some of the larger structural questions about, what should we do with the Supreme Court? I very much am supportive of ways that help decenter the Supreme Court. I completely agree the court plays too large a role in our society, and that raises the stakes of everything in ways that I think are really harmful for our democracy. I think term limits are a great idea. I also think, and this is a proposal that hasn't gotten as much attention, and I wish it would. I think even absent term limits, you could do this by statute. You could simply give each president 2 nominations per 4-year terms, decoupling nominations from vacancies so that, 3 justices step down, the president gets 2 nominations. 1 justice steps down, the president gets 2 nominations. And it would eliminate strategic retirements. I think it would lower the temperature on our nominations process because every president would get a predictable number. And, and I think there's other tricks you could do, like they blow up at the end of the president's term, so you don't have the same incentives to try to hold them over for the next president. And so I think there's steps like that could help turn the temperature down on the judicial nominations process. I think it would sort of run the numbers on this. I think most likely over time that would lead to a larger court than we have now. I think a larger court, particularly if it's done in a way that is not simply a power grab for one party, if it's done in a kind of gradual way and a principled way, might lead to some of the positive outcomes that Eric was talking about as well. I think it would be great for the court to have to meet in panels. And when litigants are raising cases where you don't necessarily know who's going to be on the panel deciding your case. I think that would discourage people doing the kind of envelope pushing that we've been seeing now in Dobbs, for example. I think it would discourage some of the more aggressive litigation. And I think it would encourage the court to be more careful in terms of pushing the boundaries in terms of precedents as well. So I think there's a lot of interesting ideas out there, and those are just a couple, and I'm happy to chat more about them in the Q&A.
So I want to give our Professor Freedman a chance. Professor Freedman has been a long time litigator in the Supreme Court and very influential public intellectual about these issues. I want to start off our question and answer with a chance, Professor Freedman, for you to give any perspective or response you might have, or even any questions for the panelists.
Where are you, Eric?
I'm here. Right there.
Well, of course, what unifies all this is the very idea of checks and balances. Right? You can go off and attack the Supreme Court, but after all, it's there to check the excesses of democracy. It's there exactly so that it doesn't instantly reflect popular will. And you can go attack them for aggressive power grabbing, but of course, the way checks and balances are supposed to work is everybody grabs for power. That's implicit in human nature, but they check each other, which is what's not been happening, right? What's The part that's more scary than usual, right, is if the dominant political force also takes control of the so-called independent judicial branch, and then there's nobody to stand in their way, which suggests that those are the sorts of mechanisms. You know, we've got to give everybody an incentive to want to curb the others. And obviously, some things that have eroded that, like the rise of parties, which nobody foresaw, and the rise of, you know, hyper-partisanship abetted by the Supreme Court and gerrymandering and so on. Some of those things are probably too big to bite off at any one time. Some of them might be fairly straightforward and simple, including one that I'll just toss out, which is repeal the judges' bill, which was a power grab, right? When the Supreme Court got control of its own docket, and it was, at which time it was thought that 300, 400 a year would be a reasonable number, not the 800 that they had. And that was before computers and lockers and stuff. But by the time of Warren Burger, 120 was a crisis and we had to do something about it. And now we're down to 50. Well, of course, those 50 are self-selected so self-consciously, so we can make big law, and that, you know, is not only bad for whatever comes out, but erodes our self-perception as a court, right? And so I guess what I would ask each of you is, how do we give the political players the incentive to check each other, which is plainly what's.
I disagree with your premise, Eric. I'm sorry.
Okay.
It may not be a huge shocker, although I respect your work unbelievably. I don't think the Supreme Court was meant to be part of a separation of powers and checks and balances in the way you mean. I certainly think the Supreme Court should, and probably was meant, at the federal level anyway, to play a role in the Fourth and Eighth Amendments. We need judges to make sure that we have values like double jeopardy and no self-incrimination and no coerced confessions. And I'm a huge believer that judges, including the Supreme Court, should play a very, very big role in that. And that is a checking function on the executive branch of the federal government and the police forces and the state judicial systems post-Reconstruction. That is a check and balance. I agree 100%. I do not agree that the court was meant to be or should ever be a check and balance when it comes to issues like abortion and gun control and the role of money in politics, absent the most extreme and obvious error that is inconsistent with clear constitutional text. That's not what they thought. Before the Constitution was ratified, a guy named Brutus said, don't do this. It gives judges too much power. And Hamilton in Ferris number 78 said, don't worry about it. They have no sword, they have no purse, and they won't strike down laws unless there's an irreconcilable variance. If not variance. That's not the standard the court uses. I don't know why we think elite lawyers from Harvard and Yale should have the final say over abortion, affirmative action, gun control, and dozens of other issues that are really important that we give them power over. I do understand why we give judges ultimate say over what happens in courtrooms when it comes to evidence and that kind of thing. So I don't think, either as intended or certainly as it's been now applied, we need the judges to be our moral guardians. We need them to guard the clear text of the Constitution where it's clear, and where it's not clear, they should step down. And that is just about every court that doesn't involve the Fourth to Eighth Amendment. So I don't agree with your premise on the checks and balances.
I'll jump in with a couple of other thoughts. First off, I think the idea of, you know, kind of reforming the cert process and dramatically increasing the number of cases that are going directly to the court is a really interesting one. You know, sometimes when people talk about court reform, they talk about jurisdiction stripping, and I've always been worried about that, in part because of the history. If you look at often what have jurisdiction stripping movements sought to do, it's often been targeting things like civil rights cases, and I've worried about kind of normalizing that as a precedent. But I think sort of jurisdiction expansion in a way, right, dramatically increasing the number of cases so that much more of the docket is a workaday docket is a really interesting idea and something that hasn't, I think, gotten the attention it should as people have been discussing different court reform options. In terms of separation of powers, I guess I would raise a slightly different point, which is I think Congress has really abdicated its role in the kind of constitutional conversation that you're supposed to be having between the courts and the political branches. You know, there are some instances where the court rules in a way where, that's where it's essentially the final word. If you can't amend the Constitution, you're somewhat stuck. But in a lot of different arenas, some of the court's most notorious rulings, in fact, are either, statutory interpretation such that Congress could amend the law, or are constitutional decisions where there is a congressional response. I mean, Dobbs, you could have, Congress could step in and institute, pass a law that would protect abortion rights nationally. Now that might get litigated too, but there's certainly a congressional response that could happen. And what we've seen is a dramatic reduction over time in the number of instances where Congress has been in constitutional dialogue with the court. And there's a lot of reasons for that. I would lift up, kind of broader issues with the fact that, it's not just our courts that aren't working very well, it's our democracy writ large. And so, when we're talking about court reform, we're talking about fixing our courts, I think there's also a broader conversation to have about fixing our democracy, and addressing some of the reasons why we don't have a Congress that's functioning very well often, filibuster, gerrymandering, et cetera, voter suppression. There's lots of different ways that have led our Congress, our representative institutions to not be all that representative or responsive. And so, I think that's another piece of the checks and balances that's sort of broken right now. And, in some ways, it's both harder to fix because it's our democracy, but in some ways, there are, I think, really important, the For the People Act, for example, was a bill that came very close to passage. I think there are real reforms that have that are thoughtful and that could do a lot to improve the functioning of our democracy, that would have real benefits when you look, not just for democracy writ large, but also in terms of providing other avenues to check the court.
Two quick points. A very smart guy writing in the 1890s, again, going back to my thesis that this is not really a different moment in time. A very smart guy writing in the 1890s said, that Alicia's points she just made, that the reason Congress has abdicated its role, and there's no question Congress is dysfunctional, is because the Supreme Court has taken on too much of a role when it comes to constitutional interpretation. His name was James Bradley Thayer. He recommended extreme deference, especially to acts of Congress. He's writing in the 1890s saying the court has taken on too much power. I agree Congress is broken for a lot of myriad complex reasons. One of the reasons Congress is broken is because of the Supreme Court. The other thing I want to say real quick is I agree with every single reform both Eric and Alicia are talking about. I think all these small things would be great if we could do them. But we will never really make a difference until we recognize this institution is not a court of law and never has been, or we reform it to become a court of law. But it is not today a court of law, but we think of it as a court of law. So my wife would say to her business school students, your eyes are not on the ball. The ball here is what is this institution supposed to do and what kind of institution is it? Those are hard questions, but I can tell you what it's not. It is not and never has been a court of law.
So I'm going to ask a very quick first question and give you all a chance to come up with questions and then leave it the rest of the time to you all. So my question, as with many things in my mind, is based on my older brother. So my brother would say and has said, in response to things that the Supreme Court does, he's not a lawyer, he would always say, well, elections have consequences. And I think, Eric, he would say, he doesn't, and I think many people who aren't lawyers don't think of the Supreme Court as a court of law. They think of it as another political body which expresses the political sort of goals and motivations of the people who have the power to nominate them and confirm them. So I think we as lawyers maybe think about it as a court of law too much. And the perception is of why it's different from all these other courts is that the consequence of winning or losing an election that the president gets with variable sort of numbers, the chance to direct the court. And I do think most lawyers look at court decisions and they just assume off the top of their head that it's not based on law, it's based on whatever their political objectives are. And it's we who want to see it as something other than that. If their perception is true, or I think that is true that they think that, is the answer to your question, let's just acknowledge that it's not a court of law, and those who care about these things should get out and vote and make sure that people who care about the things that they care for vote too.
I would ask your brother what I've asked. I do a lot of radio, and I talk to a lot of non-lawyer audiences, non-law student audiences all the time. Doctors, accountants, economists, philosophers, and less educated people who I've talked to all have the same response when I ask this question. If it's not a court of law, which I think most people do think, I agree with you, outside of law schools and the legal academy, I agree with that. If it's not a court of law, in what sane world would you want to be governed by elite lawyers from Harvard? You know, Scalia once said, and he's a hypocrite on this point, but he once said that the right to death issues that Supreme Court were wrestling with, they have no more insight into the balance between euthanasia and dignity with dying and all of that than 5 people picked at random from the Kansas City phone directory. Scalia's right about that. Scalia's 100, he didn't act on it. He voted to strike down over 140 laws in his career, almost none of which are based on textual history. But his insight was correct. What society says, you know what, we don't know that. We have some idea of gun rights and some idea of gun safety. We got to work it out. Or this issue about abortion is really difficult. Some people think the fetus is human. Some people think women's equality is impaired. They can't have, abortions. That's my view. Affirmative action is tough. How do you make up for all these ills of the past without racial criteria? What sane society says, I know, let's get 9 lawyers from Harvard and Yale to tell us what they think. No, that's crazy. So my answer to him is, why do you live in a country where you're willing to delegate these country-defining issues, these issues that define us as a people, define our dignity, to like tenured lawyers from Harvard and Yale? It doesn't make any sense.
So, Alicia, do you want to?
Sure. I guess I do think that I guess I would say I think you're right that public, kind of broad public perceptions, there's a disconnect between how lawyers think about the court and how the public at large sees it. I guess I differ in that I do think that there is a role for the court. We need an institution that is separate from the political branches, that is there, that can protect rights, that can, protect democratic norms, and that isn't subject to the same kinds of political forces that our elected leaders are. There have been times in our history, not enough of the time in our history, where the court has played that role. I think in terms of why would you ever entrust unelected people with that power, I think here's where we get to maybe some of the dysfunction in how our selection system functions right now. I think if it were working well, there would be, over time, kind of ties between the court and the people rooted in who's elected president, right? Over time, as the public evolves, different people become president and, and they would have their nominations. But, now the way the system works, President Trump had 3 nominees to the Supreme Court in a 4-year term. Jimmy Carter had 0. President Obama had 2 in 8 years. And so what we've seen, through a mix of luck and some constitutional hardball by Mitch McConnell and others, is a court that's pretty wildly disconnected from who's held office and from kind of the overall political leanings of the country. I guess I think it's not as clean a question. Like, I think that you need the court needs to be politically accountable in some way. It needs to have some tie to public opinion, but it can't go so far in that way. There needs to be kind of a pull and push. There needs to be, which is hard to explain to your brother, but I think is how
Same with my brother.
When the court has been functioning well, I think that's how it's functioned, and I think we've seen, through a mix of bad luck and institutional dysfunction and a kind of greater pull polarization of our politics, that increasingly failing to be the case. And I think that's why I see court reform as such an important piece of the puzzle.
Yeah, I actually really want to get to questions if we have any out there. We don't have that much time. We do have time for several questions. So, Tay, if you could bring the mic around, that would be awesome.
Let me just say, it could be 9 lawyers from Hofstra.
That'll be totally different.
I'd vote for that.
Thank you for your discourse, Professor Siegler. It was nice. And I did read your 148 essay, Professor Sample, before that. But even though I knew about you before he mentioned you, but thanks, Professor Sample. I enjoyed reading that. Well, Professor Siegler, you were talking about Federalist 72.
78.
Oh, 78. But yes, 78. I remember that in grad school, and if the professor was a lawyer and he was talking about how the Supreme Court is not gonna go down to the Oval Office and say, do this or else. We're lawyers from Yale and Harvard. But also Congress has the coin, all the money. Well, Professor, what I would like to talk about is the legitimacy, about how you talked about this just now, 1857, Dred Scott v. Sandford, which made the Civil War inevitable. But I mean, of course, slavery is, everybody knows what happened to slavery. It doesn't matter what Roger Brooke Tawney said there. And also, Professor, President Lincoln didn't pay attention to the Supreme Court during the Civil War. One of his letters, he even talked about arresting. He even told one of his Union generals he was considering arresting Roger Brooke Tawney during the Civil War. So I mean, of course, the Chief Justice Rehnquist said the Supreme Court of the United States is not silent during the times of war, but we'll speak with a different voice. But I mean, there might come a time that a president, sooner or later, is going to do the same thing that President Lincoln said and just ignore what the Supreme Court says. Or maybe Congress could suspend the Supreme Court of the United States again, just like they did in 1801 and 1802.
If you're asking me if I think that the president should one day, if the stakes are important enough, decide to ignore the Supreme Court, I would give you the answer that Alexander Hamilton gave in 1787 to that question. And I'm not citing Alexander Hamilton, the founder, not the actor. I'm not citing him because I'm an originalist, obviously I'm not. I'm citing him because he was a smart guy who thought about this issue under a veil of ignorance. He didn't know if he was going to get his Federalist judges on the Supreme Court or if he was going to get the Jeffersonian local kind of anti-Federalists on the Supreme Court. So he was writing without knowing who was going to be on the court. And his answer to Brutus was, if the president doesn't want to enforce the court's decisions, the court is out of luck. So the court, and the president should do that if the president feels strongly enough. So I wrote a blog post a few months ago saying for the first time in my career that I think it's time for the president of the United States, maybe in one of these administrative law cases where the EPA does something and the judges say, no, the EPA can't do it for reasons that a fantasy, creative fiction and judges' heads, like the major questions doctrine, which doesn't exist and is an absurd example of judicial overreach. That's how I feel about that. Maybe the president says the EPA is going to do it anyway. Now what are you going to do? Now when I say that, and when I wrote that, and I got much protest from the left, they said, what about 1958 and the governor of Arkansas saying, I'm not going to desegregate my schools, and Eisenhower Republicans sending in the National Guard? Fair enough. I'm glad Eisenhower did that. I don't think President Biden or the next president, if they're a Democrat, should accede or should give weight to this major questions doctrine, which is going to limit the EPA's ability to fight climate change. First of all, I think climate change will kill us all anyway, so what's more important than that? And if the president does that once, does that mean the rule of law is over? That's what Alicia was kind of hinting at. Is the rule of law over? I would answer that by saying that many, many democracies have thrived in world history without having judicial review at all, much less strong judicial review. So I don't think judicial review is necessary for a democracy.
More questions?
First, I just want to say thank you both. That was all very insightful. My question is for Mr. Steele. You mentioned earlier that the United States is the only country or democracy that has a court like this. What are some examples of other high courts from other countries you think we should emulate?
And when I never really said what I meant by like this, courts like this. This is what I mean by courts like this. We have the oldest written constitution in the world governing the country. We have the oldest written constitution in the world governing the country. The oldest written constitution is actually Boston's, Massachusetts, excuse me, but it doesn't govern the country. And it's virtually impossible to amend. So we have the world's oldest, and we can't amend it. So we defer to like tenured lawyers from Harvard and Yale to do it. There is no other country that has, when I said a perfect storm of events that made this court not a court, those are two of the big ones. So the German Constitutional Court is pretty powerful. The India Supreme Court is pretty powerful. Neither has life tenure, of course. There's no one has life tenure to think about it, right? So and the German Constitutional Court is a constitutional court where they recognize it's not law as usual. So the nomination process is very different. And they try to get actually like people of character and people of good judgment who happen to be lawyers on the German Constitutional Court. I'd be curious to Lisa's views on this. I think a specialized constitutional court would be a good idea. I don't know if it's consistent with Article 3. I would say it is, but there are people who say it's not. But the least we could do is end life tenure and maybe through panels or some method, have judges who do nothing but constitutional law, which isn't really law. Because the skills it takes to do that are different skills than the skills it takes to do statutory interpretation and other things judges do.
I think, I would also support term limits for justices. I think that's a very simple lesson we could take from, as you said, virtually every other court in the entire world. I think, stepping back, I think we would benefit from reforms and changes that would help decenter the court from our system. I mean, we need a court, and we need a court that's going to protect rights. We need a court, as I was saying, that's going to support the functioning of our democracy. I think we need a less involved court than we have right now. And the question is sort of incentives-wise, how do you get there? I'm not sure that I would want to see a specialized constitutional court, because I worry that that would actually incentivize sort of more activity. You know, you sort of give them a hammer and everything's a nail. You know, that I think that might encourage more aggressive behavior on the part of the court. I've been interested in reforms that could lead to, like I said, sort of a panel system, so you don't necessarily know which justice is going to appear in front of you, because I think that would discourage from the side of the litigants, which cases get brought, and I think that would influence how the court would behave in hearing particular cases, because again, you don't know who's going to be the next panel that's going to decide, the next case building on the precedents that you've determined. I think other ways of altering the court's jurisdiction are really interesting. I also think we would benefit from changes in norms in terms of who reaches the court. I agree that we shouldn't have a court that's made up entirely of Harvard and Yale graduates and people that we used to have politicians, people who had electoral experience, varied life experience on the court in a way that we don't now. It's a very kind of narrow, specialized path, and I think that too has led to some real tunnel vision in terms of how the court has thought of its role. So I think there's some changes that we could make without even needing to change a law if we had a real sort of rethinking of what the path should be towards the bench and what we view as the most important qualifications for justices.
Other countries, just to go, the relationship it's a perfect storm of three events: an incredibly old constitution that's really hard to amend, and a long 200-year history of strong judicial review. No other country has those three things. And India and Germany, whose Supreme Courts are strong, there is still more of a dialogue. We were talking about dialogue earlier, and I really love that point, between the other branches of government and the court. But I'd like you to reflect on just, when you leave today, the proper balance between respect for the fetus and a woman's equality, or the proper balance between, nobody wants racial criteria, but we live in a country that's been racist for 200 years, or the proper balance between free speech and corporate domination of elections, and I can go on and on. Are those legal questions to you? Do those strike you as questions that can be answered based on text, history, and even precedent? No, those aren't legal questions. Those are public policy questions of the highest order. There is an awareness in Europe, I think, that when judges, they're called judges, but when they decide those kinds of questions, they're not doing it as lawyers. They're doing it in some other capacity. And most importantly, they don't have that much power. I mean, the German Supreme Court can only do so much because of the traditions of that country. Same thing with India, same thing with the European Court of Human Rights. Right? Our court has the most power by far of any court in human history. And we should really think about it.
So what's our timing, Teo?
We're going till about 5 o'clock, so.
I don't think there's class in this room, so I'm willing to go for a while.
Right.
Okay, so let's have some
until 2, but we definitely.
Let's keep going.
Hi. I just want to say, everyone has said it already, but thank you guys again for coming to our school and talking about these issues. So we've spoken about how respect for the court waivers are decreased through time, and how none of us really have a choice when it comes to their decisions. We kind of just have to follow it. And we have seen the national outrage after many Supreme Court decisions, especially the one with Dobbs. So I have a question, do you believe that the court should begin to consider nationwide opinion? Do you believe that how we all, I guess, have a choice in the president, how we all have a democratic opinion, how they should begin to consider how the people of the United States would react, or how they feel these decisions should be made?
That's a great question, and it's a difficult question, because part of the reason we have a court in the first place is that you want to have an anti-majoritarian institution, right? That you think there are certain rights, et cetera, that shouldn't be just subject to the whims of the majority, and you need a court to step in and protect those rights. And that's part of the reason why we have life tenure for judges and other dimensions of judicial independence for the court, to sort of insulate the court from political pressure, so that the court isn't, the justices aren't worrying about how it's going to play out in the next election. They can focus on the law and the facts in front of them. I think how I think about this issue is that I think it is appropriate for judges to insulate themselves in that way. I think, though, that we have sets of interpretive, as I was saying in some of my earlier remarks, there are interpretive principles and norms that are supposed to also constrain judges and are an important part of thinking about, what is the role of the court in a democracy. A court shouldn't just be following whatever public opinion says, but it's also a problem, as Justice Kagan was saying, if, the personnel shifts on a court and then all of a sudden the court's ruling totally different as well, because that doesn't feel like a court acting like a court either. And so, I don't think some of these things lend themselves to clean answers. I think the answer is that, a court shouldn't be, looking at the public opinion surveys every day and making its ruling in that way. I think there are interpretive principles and norms, things like respect for precedent, things like these principles that you're supposed to limit yourself to the cases in front of you, principles like mootness that limit what the court is actually ruling, that are really important in making sure that the court isn't overstepping. And but then I think also factually, it is the case that, the court has historically not deviated too far from public opinion. And when it has, there has been pressure, efforts to court pack, efforts at court reform that I think have certainly put pressure on the justices to over time kind of moderate their decisions and, come closer to where the majority of the public is. And, I think there too, I don't know that it's a clean answer. You don't want too much of that because then, why have judges in the first place? But I think there can be kind of a healthy back and forth where, the court, you don't want judges up in the sky either. So having some back and forth with political pressure can be, I think, a valuable counterbalance and ensure that the court doesn't depart so far away that it kind of loses its legitimacy.
I think it's a great question. I think we shouldn't lose sight of the fact that they are situated in a moment of time, no matter what they think or say or do, and are influenced by that moment of time, regardless of any conscious desires. I think I want one of two worlds. I want a world that Alexander Hamilton wanted, where the justices would almost never strike down laws, absent a clear, irreconcilable variance. I'm not talking about the 4th to 8th Amendments now. I'm not talking about issues that involve double jeopardy, self-incrimination, the court, don't everything else. If they did that, I would say public opinion shouldn't come into play because what's an irreconcilable variance? Very few cases are going to meet that standard. It's kind of a legal standard, and judges and lawyers understand legal presumptions. So the presumption would be everything's constitutional, and the plaintiff has an incredibly heavy burden of showing that it's not. We haven't had that world since 1857. In the world we've had since 1857 and Dred Scott, then I think the judges should absolutely take into account how their decisions are going to play with the public. Richard Posner, the most famous judge ever not to be on the Supreme Court, in my opinion, and someone voted America's leading intellectual period, not just legal, of the 20th century. It's a good friend of mine, and he used to say to me all the time that what I called a non-legal factor, how this opinion is going to play out on the ground or how the public's going to perceive it or what it's going to do to the elections or whatever. He used to yell at me all the time and say, of course those things matter. These judges are making decisions that affect all of those things. If they're not going to think about the consequences of it, what the heck are they doing? Well, he's the smartest man I ever met. So.
One other, can I just make one other point, just as you were talking, it made me think of it. I also think it's important when we're thinking about the role of the court and, constraining the political branches or not. It is only very recently that we've actually had a real democracy in the United States, right? I mean, until the 1960s, the Voting Rights Act, the Supreme Court actually played a very important role in bringing that about as well. You didn't actually have, I think, a democracy that I would describe as having much kind of democratic legitimacy. So I also think as we're thinking about kind of moments in time, it's important to also think about, how democratic were our democratic institutions. And it might be that the balance as we're thinking about, well, what is the role of the court? How should the court be interacting with our democratic institutions? That might differ as we've had institutions that are actually more democratic.
One last icing on that. Oliver Wendell Holmes said, actually James Bradley Thayer said it too, we could live without judicial review of Congress. They both wanted judicial review of the states. Here's an empirical fact for you. Throughout most of American history, the Congress of the United States, despite its dysfunction, has been well to the left of the Supreme Court of the United States. And we have a much more thriving democracy and much more equality today if the Supreme Court actually acted like a court and deferred to Congress, not to mention the American people, because the court took the Reconstruction Amendments that were meant to help the newly freed slaves, and by 1890, those Reconstruction Amendments were used exclusively to help big companies and railroads. Congress has been more right securing than the Supreme Court for most of our history. It's important to keep that in mind.
So I see one more question back there. We have two more, so maybe these will be the last two.
Thank you both for your time again. I think we would all agree that transparency is increasing transparency is definitely a great, probably first step in solving a lot of these problems. What would you both suggest on how to increase transparency in the granting and denial of cert? Because I think that's one of the biggest sort of aspects of the Supreme Court that remains in the dark.
I've written about this. I think one of two things should happen. It's easy. Either we should get the justices on record as to how they vote when they vote to grant certiorari. Now, a friend of mine, Mark Tushman at Harvard Emeritus, says if we do that, then they'll just play a different game and just all vote to grant cert in every case they vote. Well, if they're going to act in bad faith, what can we do? But I would like to see who voted to grant cert in those cases where the court grants cert. In the 2,500 cases they don't grant cert, that would be a heck of an administrative burden, probably. I'm open-minded about it. But it's really important for the lawyers to know which justices wanted to hear the case. And even more importantly, it turns out, according to Justice Powell's papers, William Rehnquist almost never, during the time Powell was with him, voted to hear a civil rights case. Like almost never, like really, like never. When the civil rights would go on the side of the left. Well, that's important to understanding the legacy of William Rehnquist as a Chief Justice. So now Akil Lamar at Yale has said to me, you don't want to do that beforehand for this reason and that reason. But at the end of every term, June 30th, there's no reason why then we can't just make public the votes that happened during the year. That's the least we should do.
I confess I haven't given it much thought. I will read what you've written. I think I do agree that more transparency makes sense. And I think, as you were saying, something that maybe does, makes things public at the end of the term seems like certainly something worth thinking about. Add it to my reading list.
That was Akil's idea, not mine.
So I think we're going to take one last question up there. If we can pass the mic over there.
I want to echo what everyone's been saying so far, and thank you folks. And warn you that I'm aware, so anything I say might seem a little bit lacking some information. Let me know. I'm not being partial. I want to word this, but I want to go back to what Professor Freedman ended up mentioning with checks and balances. If the original framework was to maintain a system of checks and balances in order to keep the system kind of fair and in check, and if over time the laws that passed ended up resulting in a lack of what that intended fairness and balance was supposed to be, if these laws have kept people who are being put in power and benefiting from that power, how do we, aside from daily fixes, how do we go back to the original goal without removing that human factor, which is the political power that they want? And if we can't go back to the original goal, are we kind of need to consider political perspectives when it comes to moving forward with the profession?
I would just say that democracy is terrible except for all the alternatives. I don't know how to fix our dysfunctional Senate, which is not representative of one person, one vote in any way, shape, or form. Our dysfunctional electoral college. I don't know how to fix the fact that in a Texas case last week, the Supreme Court let a man be put to death when three people on his jury said they were opposed to interracial marriage. And it was a case involving race. And this is in recent times. 3 out of 12 jurors in Texas said they opposed interracial marriage. I don't know how to fix our democracy. There's only one thing I do know. The Supreme Court has never, and can never fix it. And if anything, the Supreme Court has warped it in Bush versus Gore, in gutting the Voting Rights Act, and turning the Reconstruction Amendments on their heads. So whatever the answer is, it is not with elite, life-tenured lawyers from Harvard, Yale, and one from Notre Dame. I can assure you.
I just want to, I concur that some of the most I would say probably the most devastating legacy of the Roberts Court has been its democracy record, you know, across a whole host of arenas, money in politics, voting rights, redistricting. You know, all I'll say, I agree the record is devastating. I guess I would say I don't see, particularly in arenas like partisan gerrymandering, you know, I think you actually need a court. The problem is we don't have the court that we need. You know, I think there is a critical role for the court to play to ensure that we have democratic institutions that are functioning and that are representative, and that you don't have sort of self-interested actors, you know, essentially entrenching themselves. I mean, that was very much an issue in partisan gerrymandering cases that the court heard. Unfortunately, the court ruled in Rucho that, you know, these were political questions and that they weren't, there wasn't going to be a federal constitutional remedy, at least for addressing some of that. But in my mind, these democracy cases, you know, sort of underscore the fact that we actually need courts. But the problem is the court that we have now isn't playing the role that it should be.
Just one last ultra depressing thought. And this one really is, this is beyond depression. This is country ending as opposed to just depression, but potentially country. So Lisa just said that the Supreme Court took federal courts out of the gerrymandering cases, partisan gerrymandering cases. We can have a reasonable debate whether that was right or wrong. But this term, so the Supreme Court removes federal courts from being able to decide gerrymandering cases. This term, the court's going to remove state Supreme Courts from being able to do that. And they're going to do that for no other reason than to benefit the Republican Party. And at this moment, which it will, and at this moment in time, that's if state Supreme Courts are taken out of by the United States Supreme Court, ruling on state election law issues under state law, which is what the court is going to do beyond all reason. We're in deep trouble, folks. But that's another example of how the court is such a potentially dangerous mechanism in being anti-democratic. Because whatever you think about federal courts reversing partisan districting maps, that's a hard issue. Certainly state Supreme Courts acting under state law should be allowed to do that, as the North Carolina Supreme Court did last year, and the court's going to say they can't.
I'll say I haven't given up on the Supreme Court on that one. I think we'll see. I mean, I think you're absolutely right that this case is, you know, one of the most critical, you know, democracy issues to reach the court in, you know, in its history. I mean, the kind of extreme version of that case could be really devastating. I think you've seen a lot of pushback, including, you know, from some unusual sources in that case. So, for example, the Conference of Chief Justices, which represents all of the state Supreme Court chiefs across the country, filed a brief, which is very, very unusual, especially in a case that kind of has the partisan valence that this case has. They formally took no position in the case, but they took a very clear position in the case, saying that this would be really devastating and really inconsistent with principles of federalism and comity. So we'll see. I'm holding out hope, so I won't let us end on a fully depressing note there.
I hope I'm wrong.